Let me now respond to the question of the death penalty. Japan considers that the issue of continuing application of death penalty should be studied carefully based on domestic public opinion, the crime situation, and the criminal policy of the country concerned. And a decision on this issue should be made by each country on its own accord. The death penalty system in Japan is an issue that should be studied carefully from various standpoints, including how to achieve justice in society, while paying full attention to its public opinion. The majority of Japanese people consider the death penalty to be unavoidable in case of extremely vicious crimes, and in view of the current situation in which heinous crimes such as mass murder and abduction murder continue to take place, our government believes that the application of death penalty is unavoidable in case of significantly serious heinous crimes, and therefore the abolition of death penalty is inappropriate. For this reason, Japan cannot support the resolution adopted by the United Nations General Assembly seeking a moratorium on execution as a precedent leading to the abolition of the death penalty. We are not considering either granting a moratorium on execution or abolishing death penalty. At the same time, I would like to stress that in Japan, death penalty is mandated as a statutory penalty only for the most serious crimes, such as murder and robbery with murder, and sentenced of death are handed down only in extremely heinous cases and after very cautious trials by courts. There was also a question regarding Japan's裁判員 system, which is due to commence in May 2009. In this system, those members of general public called 裁判員 are to participate in deciding conviction or acquittal and sentencing with equivalent weight in their opinion as professional judges. Sufficient explanation will be given to the 裁判員 regarding necessary legal knowledge and procedures of trial before and throughout the trials by professional judges. Under the new system, appropriate decision is expected to be reached through discussions between judges and 裁判員 by sharing different perceptions and experiences. As such, fair trials are expected to take place through cooperation between them under the new system. We are also requested to explain how we incorporated opinions of civil society in the process of preparing our national report. Discussion meetings with NGOs and ordinary citizens have been held as a part of the process for drafting our government report for each human rights convention. In addition to this, NGOs and the Ministry of Foreign Affairs have co-hosted the Public Forum for United Nations Reform 6 times so far since 2005. And each time we had a separate session to exchange opinions with citizens, members of NGOs, and international organizations on human rights issues in this framework. In drafting our national report for UPR, the Ministry of Foreign Affairs also posted information on the UPR system and the process on its website and asked for opinions of NGOs and ordinary citizens about our government report. As a result, we received opinions from NGOs and 11 NGOs and 214 ordinary citizens. Before finishing my opening remarks, I'd like to repeat our basic position. As we recognize there is still room for improvement, our government is taking and will take further efforts for bettering human rights situation in Japan. As for our efforts in the international community, Due to globalization and environmental changes, we are facing new challenges and new kinds of human rights problems, and the governments of all countries have to tackle them and take necessary measures to overcome them. Japan will continue its contribution to achieve better results for human rights all over the world, in close cooperation with the United Nations, regional communities, other national governments, and civil society. Finally, we sincerely hope that in the course of today's interactive dialogue, we could have fruitful and constructive exchange of opinions. Thank you very much.